Your property is in violation. You have 14 days to comply or we will take action." She said it the way people say things they have practiced, evenly, with a slight forward tilt of the chin, the words arriving in a sequence meant to feel inevitable. I was standing at the edge of the dock when she delivered that line, still wearing the jacket I had pulled on at the Fairbanks Airport 6 hours earlier, still carrying the particular exhaustion that comes from crossing time zones over mountain ranges. The lake was flat and gray in the October light, the way it gets when the aspens have dropped everything and the sky cannot decide what it wants to be. I had been gone 11 weeks. I had come home to find the lodge gone. Not damaged, not vandalized, gone. A rectangle of raw earth where the building had stood for 61 years. The concrete pier footings still visible at the corners like extracted teeth. A smell of turned soil and something chemical I could not immediately name. And standing at the end of my dock, in a blazer that had no business being this far from a city, was a woman named Renata Hollis, board president of Clearwater Ridge HOA, holding a clipboard and informing me that my property was in violation. She had no idea. No idea that the dock she was standing on, the shoreline behind her, the access road she had driven in on, and the 12-acre parcel where my lodge had stood for 6 decades. All of it was mine, every inch of it. I held the deed. Drop a comment, tell me where you're from, and if something like this has ever happened to you, I want to hear it. My name is Callum Voss. I am 64 years old, and I have been coming to Garnet Lake since before I could read. The land has been in my family since 1947, when my grandfather, Elias Voss, purchased 340 acres of northern Wisconsin lakeshore from a timber company that had finished with the trees and wanted out. Elias was a civil engineer by training and a farmer by temperament, and he understood 2 things about land: that it was the only thing they were not making more of, and that a piece of paper, properly recorded, was worth more than any fence you could build. He paid $6,200 for those 340 acres. He paid a surveyor another $180 to walk every boundary line and drive iron stakes at every corner. He filed the deed with the county recorder's office in November of 1947, and he kept a copy in a metal strongbox that still sits in my closet. The hinges gone to rust, but the documents inside as legible as the day they were typed. Elias built the original fishing cabin in 1951, a 2-room structure of white pine and fieldstone, sitting on piers above the waterline at the lake's northwestern cove. My father, James Voss, expanded it in 1972, added a sleeping loft, a proper kitchen, a covered porch that ran the full length of the south face. I grew up on that porch. I learned to read there, to tie flies there, watching my father's hands work the thread around the hook with the same patience he brought to everything. When James died in 2003, the property passed to me through a will drafted by a Rhinelander attorney and recorded with the county without complication. I paid the inheritance taxes. I maintained the title insurance. I had the boundary survey updated in 2008 when a neighboring parcel changed hands and I wanted the corners confirmed. The deed had never been clouded. The ownership had never been in dispute. I was a structural engineer for 31 years before I retired, and I approached the land the way I approached a load-bearing calculation. Methodically, with documentation, and with the understanding that the numbers either held or they did not. I kept a folder for every year of property taxes paid. A folder for every survey. A folder for every permit I had ever pulled for work on the lodge. When the county updated the parcel maps in 2019, I drove to the courthouse and obtained a certified copy of the new plat. I did not do these things because I anticipated trouble. I did them because Elias had taught my father, and my father had taught me, that the record was the only thing that mattered when someone eventually came to tell you otherwise. The lodge, as it stood before October of that year, was a 3-bedroom structure of timber frame construction, 2,400 square feet on the main level, with a stone fireplace my father had laid himself over the course of one summer, each stone chosen from the lake's eastern bank. There was a workshop below the main floor and a boathouse attached at the water's edge. The property had a well, a septic system permitted in 1994 and inspected every 3 years, and a gravel drive running from the county road to the parking area beside the lodge. The whole of it sat within the original 340 acres, well inside the boundary lines Elias had staked in 1947. Clearwater Ridge, HOA, had come into existence in 2004, when a developer named Grantham Properties subdivided 180 acres on the eastern shore of Garnet Lake into 47 residential lots. Those lots were east of the lake's center line. My land was west and north. The two parcels did not share a boundary. The HOA's jurisdiction, as written in its recorded declaration of covenants, conditions, and restrictions, the CC&Rs filed with the county in 2004, extended to the 47 Grantham lots and to the common areas within that subdivision. It did not extend to my land. It had never extended to my land. My land predated the HOA by 57 years. I had been aware of Clearwater Ridge, HOA, the way you are aware of weather in a county you don't live in. They sent me a welcome letter in 2005 that I did not respond to because there was nothing to respond to. I was not a member. I had never been a member. Membership required ownership of one of the 47 Grantham lots, and I owned none of them. I filed the welcome letter in a folder I labeled, with some precision, "Not applicable," and did not think about it again for several years. The first certified letter from Renata Hollis arrived in March of the year before the demolition. I read it at the kitchen table of my house in Madison, where I spend the winters. The letter was 3 pages, dense and formal, citing several provisions of the Clearwater Ridge CC&Rs concerning shoreline vegetation management, dock construction standards, and what it called visual impact mitigation requirements. It informed me that my dock was non-compliant, that my boathouse exceeded the permitted footprint under community guidelines, and that my driveway required HOA approval before any maintenance could be undertaken. I read it twice. I read the CC&R provisions it cited. I looked up the parcel number against the county's online GIS system and confirmed, without difficulty, that it corresponded to my land and not to any of the 47 Grantham lots. Renata Hollis had apparently decided that proximity to the HOA's subdivision conferred jurisdiction over adjacent properties. It did not. There was no recorded instrument, no easement, no covenant, no annexation agreement, no court order that extended Clearwater Ridge's authority 1 inch beyond the eastern lake shore lots it had been created to govern. I was not angry. I want to be clear about that. What I felt was something more like curiosity, the kind you feel when you encounter a load calculation that doesn't add up and you want to understand where the error was introduced. I set the letter on the kitchen table, went to my filing cabinet, and pulled the folder containing the 1947 deed, the 2008 survey, and the certified plat copy from 2019. I laid them beside the HOA letter and spent about 20 minutes with them. Then I put everything back in its folder, made a note to consult an attorney, and went to bed. The attorney I called was Gerald Fitch, who practiced real estate and property law out of a small office in Rhinelander. I had used Gerald once before, in 2009, when a logging company made a claim of historic timber access across my northern boundary. Gerald was thorough and unhurried, and he had the quality I have always valued in professionals. He told you what he knew and what he didn't know, and he did not confuse the two. I faxed him the HOA letter and the relevant deed documents, and he called me back 3 days later. "They have no standing," he said. "None. Their CC and Rs are recorded against the Grantham lots. Your parcel is not encumbered by any instrument they control. This letter is either a mistake or it's a bluff." He paused. "Either way, I'd send them a response. Not aggressive, just a clear statement of the legal position, with the deed and survey attached." Gerald drafted the response letter. It was 2 pages, calm and precise, citing the recorded deed, the parcel number, the 2008 survey, and the specific language in the Clearwater Ridge CC and Rs that define the scope of their jurisdiction. It concluded by noting that my property was not subject to HOA governance under any recorded instrument and requesting that the HOA cease further contact regarding compliance matters unrelated to any property within its actual jurisdiction. I sent it certified mail, return receipt requested. The green card came back signed by Renata Hollis herself. For 4 months, nothing happened. I drove up to the lake in May and opened the lodge for the season, checked the dock, ran the well pump, inspected the boathouse. The aspens were coming in, the mallards were back on the cove, and the stone fireplace drew cleanly on the first fire I built in it. In July, a second certified letter arrived. This one was longer. It cited a provision I had not seen before, Appendix C of the Clearwater Ridge, CC and Rs, an amendment recorded in 2017, which purported to establish what the document called an extended shoreline management zone, encompassing properties within 500 feet of the HOA's common waterfront area. The letter claimed that my lodge, dock, and boathouse fell within this zone and were therefore subject to HOA architectural review and compliance standards. It included a fine of $1,200 for failure to respond to the previous notice and warned that continued noncompliance could result in remediation action. I read Appendix C carefully. Then I called Gerald. "Can they amend their CIC and Rs to annex my land?" I asked. "No," he said. "An HOA can amend its own governing documents, but it cannot unilaterally extend its jurisdiction over land it doesn't govern. That would require either a recorded easement you agreed to, a court order, or a statutory annexation process under Wisconsin law, none of which apply here. Appendix C is void as applied to your parcel." I asked what remediation action might mean in practical terms. He was quiet for a moment. "Theoretically, it could mean they attempt to hire someone to perform work on what they believe is their jurisdiction, but that would be trespass. That would be destruction of property if they removed anything." He stopped. "If they take physical action on your property based on this amendment, they will have made a very significant legal error." I thanked him and told him I was leaving for Alaska in August, a contract with a geological survey firm, 2 months in the field, no reliable phone or internet. I asked him to monitor the situation and contact me through the satellite communicator if anything urgent developed. He said he would. He did not expect anything to happen that quickly. Neither did I. I drove to the lodge one last time before leaving for Fairbanks. It was a warm August morning, the kind where the lake holds the night's coolness longer than the air does, and the mist sits on the water in long, slow rolls. I stood on the porch for a while, watching a great blue heron work the shallows along the eastern reed bed. The lodge smelled of pine and wood smoke and the dusty warmth of a building lived in for decades. I locked the door. I drove away. What I did not know, standing on that porch, was that Renata Hollis had already hired a contractor. What I did not know was that the contractor had been told the structure was an unauthorized encroachment on HOA-managed shoreline. What I did not know was that no one, not the contractor, not the HOA's own attorney, not a single board member, had pulled the county parcel records before authorizing the work. They had looked at a map. They had seen a building near the water. They had read Appendix C and concluded it gave them authority to act. It did not. The amendment was void on its face as applied to my parcel, and 5 minutes with the county recorder's records would have confirmed it. But no one spent those 5 minutes. The contractor arrived with an excavator in the 3rd week of September. By the end of that week, the lodge my grandfather had built in 1951, the lodge my father had expanded in 1972, the lodge where I had spent more nights of my life than I could count, was a flat rectangle of turned earth and concrete piers. I landed in Fairbanks on a Friday. I drove to Madison. I drove to Garnet Lake. I stood at the end of the dock in my travel jacket, looking at the place where the lodge had been, and Renata Hollis told me I had 14 days to comply. The lake held its color behind her, flat and gray and entirely indifferent to what had just been said. I looked at the raw earth where the fieldstone fireplace had stood. I looked at the concrete piers. I looked at Renata Hollis, who was watching me with the expression of someone waiting to see what kind of problem I was going to be. I was not going to be the kind she expected. I stayed on the dock for a long time after she drove away. The gravel of the access road held the sound of her tires longer than it should have, the way sound carries over cold water, and then there was only the lake. The soft percussion of small waves against the dock's wooden pilings, the smell of October mud, and something faintly metallic I eventually identified as the excavator's hydraulic fluid, still pooled in the depression where the boathouse foundation had been. I did not go to the raw earth that evening. I went to my truck, retrieved the sleeping bag I kept behind the seat, and spent the night in the cab at the edge of the parking area, listening to the lake settle into its autumn silence. In the morning, I walked the site. The excavator had been thorough. The main structure was gone to the last timber. The fieldstone fireplace, reduced to rubble, pushed to the north edge of the clearing. The workshop floor scraped clean. The boathouse was gone. The well casing was intact and capped. The dock remained. They had not touched it, perhaps because extending over the water would have required a different kind of authorization. I took photographs of everything, working methodically from the south boundary to the north, photographing each pier, the rubble pile, the well casing, the disturbed soil, the absence of everything that had been there 11 weeks before. Wide establishing shots, then close, then detail, the timestamp running in the corner of every frame. When I had photographed everything, I sat on the dock with my notebook and wrote down everything Renata Hollis had said to me the evening before, in the sequence she had said it, with the time and date at the top of the page. Then I called Gerald Fitch. He answered on the second ring, and when I told him what I was looking at, there was a silence that lasted several seconds. Gerald was not a man given to dramatic pauses, which made the silence significant. "They demolished the structure," he said, finally, not as a question. "They demolished the structure," I said. Another pause. "Callum, don't touch anything else on that site. Don't move the rubble. Don't allow anyone else on the property. Drive to Rhinelander today because we need to file before the end of the week." I drove to Rhinelander that afternoon. Gerald's office was on a side street off the main corridor, a 2-story building with a walnut-paneled reception room that smelled of old coffee and paper. The kind of office where the filing cabinets were real and the shelves held books with broken spines. He met me at the door, and we went directly to the conference table, where I spread out the photographs, the notebook page, and the documents from my truck, the deed, the 2008 survey, the certified plat copy, the 2 certified letters from Renata Hollis, Gerald's response letter, and the green return receipt cards bearing her signature. Gerald looked at the photographs for a long time without speaking. He held one of the pier photographs up to the window light, then set it down. Carefully. "All right," he said. "Here is where we are." What Gerald explained over the next 2 hours was the architecture of what had happened and what we were going to do about it. The HOA had taken physical action, demolition of a structure, on a parcel they had no legal authority over, acting under Appendix C, an amendment void as applied to my parcel because no recorded instrument had ever subjected my land to their governance. The contractor had performed that demolition under their direction. Both carried potential liability. The question was the measure of damages, and that would require more than a deed and a survey. Gerald brought in a second attorney for the damages work, a woman named Patricia Sorrell, who practiced out of Milwaukee and had spent 20 years on construction and property tort cases. Patricia was compact and precise, with the habit of writing in a small, dense hand on yellow legal pads while you talked, filling the page from margin to margin without appearing to look down. She flew up the following week, and the 3 of us spent a day at Gerald's conference table working through the claim. The first thing Patricia wanted was a reconstruction valuation. Not a real estate appraisal, but a full replacement cost analysis of the demolished structure, the boathouse, and the contents. She retained a construction estimator named Dale Ruck, who had 30 years of timber frame and lakefront construction experience in northern Wisconsin. Dale walked the foundation perimeter, measured the pier spacing, examined the rubble pile, and spent 4 hours on the property before he spoke a word to me. When he did speak, he said, "Whoever built the original structure knew what they were doing. The pier spacing is textbook for this soil type." I told him my grandfather had been a civil engineer. Dale nodded as though that explained everything, which perhaps it did. Dale's replacement cost report took 3 weeks. It was 41 pages with material and labor cost tables, regional adjustment factors, and a detailed accounting of the timber frame construction methods required to replicate what had been there. The figure for the main lodge alone was $1.4 million, accounting for the timber frame joinery, the custom stonework of the fireplace, and current northern Wisconsin labor rates. The boathouse added another $280,000. The workshop and its equipment added $190,000 more. The total replacement figure for the physical structures was $1,870,000. Patricia reviewed the report and said it was conservative. She was not being generous. She was being precise. She told me that Wisconsin courts had, in cases of willful or wanton destruction of property, applied a multiplier to replacement costs in recognition of the nature of the harm. She cited Jacob's verses. Northeastern Properties, a 2011 Wisconsin Court of Appeals decision, and a pair of federal district court cases involving similar facts. The question, she said, setting down her pen for the first time in an hour, is whether we can establish that the HOA acted with knowledge of the legal deficiency in their authority or with reckless disregard for it. If we can, the damages picture changes substantially. That was the question I had been sitting with since the morning I walked the site, and the answer, I believed, was already in the record. Gerald filed the initial complaint in the Oneida County Circuit Court on a Thursday morning, 14 days after I returned from Alaska. The complaint named Clearwater Ridge HOA, its board of directors individually, Renata Hollis, Vice President Marcus Dreer, and Treasurer Sylvia Okafor, and the demolition contractor, Lakeview Site Services, LLC, operating out of Minocqua. The causes of action were trespass, conversion, negligence, and intentional destruction of property. The complaint sought compensatory damages in an amount to be determined at trial, plus punitive damages, plus attorney's fees. A neighbor named Walt Prudhomme, who had owned a small cabin on the county road for 30 years and who had watched the excavator work from his tree line the week it happened, called me the evening the complaint was filed. Walt was in his 70s, a retired DNR warden who knew every parcel boundary on the north end of Garnet Lake the way other men know their own backyards. "I filmed some of it," he said. "Not all of it, but some. I didn't know who to call." I told him to save everything and not to discuss it with anyone. He said he had already figured that out on his own. The footage Walt had recorded showed the excavator on the site, the structure in the process of demolition, and, in one sequence, brief but clear, a woman in a blazer standing at the edge of the cleared area, watching. The timestamp was consistent with the third week of September. The woman was Renata Hollis. That footage was logged and preserved. I did not call Renata Hollis. I did not send her a letter. I filed it with Patricia and Gerald and waited for the discovery process to begin. Because the record, once you have assembled it correctly, does not need your help. It speaks in its own register, at its own pace, and it does not raise its voice. There is a particular quality to the weeks that follow the filing of a serious lawsuit. The air holding itself, the lake surface unusually flat, the birds quiet in the tree line. I had been through litigation once before, the timber access dispute in 2009, and I remembered that quality. You learn to inhabit it rather than resist it. Gerald had served the complaint and the initial discovery requests on the same day. The discovery requests asked for every document the HOA possessed relating to my parcel. Every board meeting minute that mentioned the property, every communication with the contractor, every internal email, every vote, every authorization, every invoice. They asked for the HOA's legal file, including any opinion letter from their own attorney regarding the authority conferred by Appendix C. They asked for the contractor's work order, scope of work, and site authorization. They asked for insurance documentation for both the HOA and Lakeview Site Services. The HOA's initial response, delivered through an attorney named Garrett Beal retained from a firm in Wausau, was a motion to dismiss. The motion argued that the HOA had acted within the authority granted by Appendix C, that the demolition had been performed pursuant to a valid compliance action, and that my property was subject to the extended shoreline management zone as defined in the amendment. Garrett Beal's motion was, in Gerald's measured assessment, well drafted given the facts it had to work with. The problem was the facts it had to work with. Gerald's response brief was 32 pages. It attached the 1947 deed, the 2008 survey, the certified plat, the county parcel records, the recorded CC&Rs including Appendix C, and a legal memorandum analyzing Wisconsin Statute 703.15 governing the amendment of planned community declarations. The memorandum demonstrated, with citations and without ambiguity, that no amendment to an HOA's governing documents could extend that HOA's jurisdiction over land not already subject to its declaration, that Appendix C's purported extended shoreline management zone was void as applied to any parcel not included in the original 2004 Grantham subdivision, and that my parcel had never been included in that subdivision. The motion was denied. The Honorable Margaret Calloway, presiding in the Oneida County Circuit Court, issued a 3-page order finding the HOA's jurisdictional argument without merit and permitting the case to proceed to full discovery. She noted, in language that Gerald read aloud to me over the phone with quiet satisfaction, that the recorded instruments and evidence establish, without ambiguity, that the plaintiff's parcel was not and has never been subject to the defendant HOA's declaration of covenants, conditions, and restrictions, and that the defendant's reliance on Appendix C as authority for the demolition action was legally unfounded. I wrote that language down in my notebook. I kept the notebook in the same drawer as the deed. Discovery, once it began in earnest, had the character of a slow excavation. What lay beneath the HOA's compliance action, as the documents came in through Gerald's office over the following weeks, was a record of decisions made without the legal consultation they required. The board meeting minutes came first. Gerald received them in a production of 640 pages, printed double-sided and delivered in a banker's box. Patricia sat with the box for 3 days, working through it in the conference room with a yellow highlighter and her small, dense handwriting filling page after page of a legal pad. What she found, working backward from the month of the demolition, was a paper trail of decisions made in sequence and in writing, each one more damaging to the HOA's position than the last. The board had voted on the demolition action at a regular meeting in August, the same month I had left for Alaska. The minutes recorded the vote as 5-0 in favor of remediation action pursuant to Appendix C of the CC and RS concerning the unauthorized structure at the northwestern shoreline. Renata Hollis had moved the action. Marcus Dreer had seconded. The minutes did not record any discussion of whether the parcel was actually subject to the CC&Rs. They did not record any legal opinion having been sought or received. They did not record any title search, any review of the county parcel records, or any communication with the property owner, notwithstanding that the property owner had already received 2 certified letters and had responded through counsel with a detailed legal brief explaining precisely why the HOA had no jurisdiction. That response letter, Gerald's 2-page letter, calm and precise, was in the HOA's own files. Patricia found it in the production, in a folder labeled Voss Correspondence, tucked between a copy of the July fine notice and a printout of the county GIS map with my parcel outlined in red marker. The letter had been received. It had been read. Someone had printed the GIS map and drawn the boundary line on it. And then the board had voted to proceed with demolition anyway. Patricia set the letter on the table in front of me and tapped it once with her pen. "This," she said, "is the document that moves us from negligence into willful and wanton." They knew the legal objection had been raised. They had it in writing. They voted to proceed without resolving it. She picked up her pen again. That is reckless disregard. Arguably, given the specificity of the objection, it is something worse. The HOA's own attorney, a woman named Claire Vesper, who had advised the board on the Appendix C amendment in 2017, had been asked by Garrett Beal's firm to provide a litigation support memo on the jurisdictional question. That memo arrived in discovery under a partial privilege assertion that Gerald challenged successfully. The portions produced showed that Claire Vesper had, in a 2017 email to Renata Hollis, flagged what she called a potential limitation on the zone's applicability to non-subdivision parcels, and recommended that the board obtain a title review of any parcel before initiating compliance action under Appendix C. That email was dated October 2017. The demolition had occurred in September of the year I went to Alaska. The recommendation had been in the HOA's files for nearly 5 years before they acted. They had not obtained a title review. They had not obtained any review at all. I read that email in Gerald's conference room on a gray November afternoon, the windows running with condensation, the smell of old coffee and radiator heat filling the room. I read it twice. Then I set it down and looked out the window at the street for a moment. "Logged and preserved," I said. Gerald nodded. "Patricia's going to build the willful and wanton argument around this. Combined with the Voss correspondence file, it is a strong foundation. The contractor, Lakeview Site Services, settled separately and early. Their attorney contacted Patricia 6 weeks after the complaint was filed, and after 2 rounds of negotiation, Lakeview agreed to a payment of $320,000, their insurance policy limit, in exchange for a release of claims against the firm and its principal. Patricia recommended accepting the settlement as to Lakeview, because the deeper liability sat with the HOA, and because the contractor's insurance funds were finite. The Lakeview principal, a man named Terry Goss, provided a sworn deposition before the settlement closed, testifying that he had been told by Renata Hollis that the property was HOA-managed shoreline, and that the demolition was an authorized compliance action. He testified that he had not independently verified the property's ownership status, had not pulled a permit, and had not been provided with any title documentation. He testified that he had asked whether the property owner had been notified, and that Renata Hollis had told him the matter had been handled through the HOA's compliance process. Terry Goss's deposition was read into the trial record in full. The trial itself lasted 4 days. Judge Margaret Calloway presided, the same judge who had denied the motion to dismiss, and she ran the courtroom with the economy of a jurist who has seen every variety of procedural delay and has no patience for any of them. Garrett Beal represented the HOA and its individual board members. Patricia presented our case methodically, without drama, in the order a careful professional would present it. She began with the deed. She put the 1947 deed on the screen and walked the court through the chain of title from 1947 to the present. 4 transfers, each properly recorded, each unambiguous. The ownership of the 340-acre parcel arriving at my name without interruption or dispute. She put the 2008 survey on the screen, with the boundary lines and the iron stakes and the parcel number. She put the certified plat copy from 2019 on the screen. She put the recorded Clearwater Ridge CC and Rs on the screen, with the jurisdictional language highlighted. The language that confined the HOA's authority to the 47 Grantham lots on the eastern shore. She put Appendix C on the screen behind Wisconsin Statute 700 3.15 and walked the court through the specific provisions that made the purported extension of jurisdiction void as applied to my parcel. Then she put Gerald's response letter on the screen, the letter Renata Hollis had signed for. The letter filed in the HOA's own folder marked Voss Correspondence. The letter in their possession when they voted to demolish the lodge. Then she put Claire Vesper's 2017 email on the screen. Garrett Beal's defense rested on the argument that the HOA had acted in good faith under a reasonable interpretation of Appendix C, and that the damages claimed were speculative and excessive. For the good faith claim, Patricia had the correspondence file and the Vesper email. For the damages, she had Dale Ruck, who testified for an afternoon about timber frame construction costs, regional labor rates, and the replacement value of a 60-year-old structure built to my grandfather's specifications. Dale was a good witness, unhurried, precise, and entirely unimpressed by Garrett Beal's cross-examination. When Beal suggested that the replacement figure of $1.87 million was inflated, Dale said, quietly, that the figure was conservative, and he explained why in the same methodical way he had explained it to me on the dock 6 months earlier. Patricia's closing argument was 40 minutes. She did not raise her voice once. On the morning of the fourth day, the courtroom held the particular stillness of a room where everyone present understands that something is about to be settled permanently. The smell of it was institutional, carpet cleaner and old wood and the faint metallic undertone of the heating system working against a cold Wisconsin morning. I sat at the plaintiff's table with my hands flat on the surface and waited. Judge Calloway entered at 9 o'clock. She arranged her papers without hurry, looked at the room over the top of her reading glasses, and began to speak. She found that the Clearwater Ridge HOA had trespassed on my property. She found that the demolition of the lodge, the boathouse, and the workshop constituted conversion and intentional destruction of property. She found that the HOA had acted with reckless disregard for my legal rights, having received a detailed legal objection in writing, having possessed an internal legal advisory recommending title review, and having proceeded with the demolition without taking either step. She found the individual board members, Renata Hollis, Marcus Dreer, and Sylvia Okafor, jointly and severally liable alongside the HOA entity because the board vote had been taken in their individual capacities as decision-makers, and because the evidence established that at least one board member, Renata Hollis, had been personally present at the demolition site. She awarded compensatory damages of $1,870,000, consistent with Dale Rook's replacement cost analysis. She awarded consequential damages of $480,000 for loss of use of the property during the period of demolition and reconstruction. She awarded attorney's fees and litigation costs of $620,000, finding that the HOA's conduct warranted a fee-shifting award under Wisconsin's bad faith litigation statute. And then she reached punitive damages. The standard for punitive damages in Wisconsin required a finding that the defendant had acted maliciously or in intentional disregard of the plaintiff's rights. She found that standard met. She found that the combination of the correspondence file, the Vesper email, and the physical presence of the board president at the demolition site established intentional disregard beyond any reasonable interpretation of the evidence. She looked up from her papers when she reached the punitive figure, and the courtroom was very quiet. The court sets punitive damages at $29,030,000, she said. The number arrived in the room the way a load calculation resolves, not with drama, but with the finality of arithmetic. Patricia did not move. Gerald wrote something on his legal pad in a small, careful hand. I kept my hands flat on the table. Total judgment, $32 million. Judge Calloway was not finished. She turned to the matter of equitable relief, and here her voice carried the particular weight of a jurist who intends to be obeyed. She ordered the Clearwater Ridge HOA to fund the complete reconstruction of the Lake Lodge to the specifications documented in Dale Ruck's replacement cost report. The same lodge that had stood on the northwestern cove of Garnet Lake since my grandfather drove the first pier in 1951. The same stone fireplace my father had laid one summer stone by stone from the eastern bank. The same covered porch where I had learned to read and to tie flies and to be patient. Construction was to commence within 90 days of the judgment. It was to be completed under the supervision of a court-appointed monitor. The HOA's CC&Rs were to be amended, under court supervision, to remove Appendix C in its entirety, and that amendment was to be filed with the county recorder's office within 30 days of the judgment date. She noted, in language that carried no ambiguity whatsoever, that failure to comply with the reconstruction order would constitute contempt of court and would be treated accordingly. She set down her papers. The record in this matter, she said, speaks without equivocation. The plaintiff's ownership was established, documented, and communicated to the defendants before any physical action was taken. The defendants proceeded regardless. The law does not reward that choice. She gathered her materials and left the bench. Gerald called me that evening while I was sitting at the kitchen table in Madison. The deed and the survey and the notebook page from the first morning at the dock spread in front of me. The same documents I had carried to Rhinelander the afternoon I returned from Alaska. He read the full written judgment order aloud, every line of it, his voice steady and unhurried the way it always was. When he finished, there was a silence on the line that lasted several seconds. "Callum," he said, "that is one of the cleaner rulings I've seen in 30 years. I thanked him. I thanked Patricia. I sat at the table for a while after I hung up, looking at the documents, looking at the photograph of the concrete piers from that October morning, looking at the deed in Elias's careful hand. I was not exultant. I want to be clear about that. What I felt was something quieter. The specific relief of a load calculation that has been checked and found to hold. The sense that the numbers had done what numbers do when they are correct and the record is complete. The HOA's board of directors resigned within 2 weeks of the judgment. All three, Renata Hollis, Marcus Dreer, and Sylvia Okafor, submitted their resignations in writing to the remaining HOA membership, which then elected an interim board tasked with managing the judgment's financial obligations and the court-supervised reconstruction. The HOA's insurer covered a portion of the award. The remainder was satisfied through a special assessment levied against the 47 Grantham lots. Those homeowners had not voted for the demolition. They were paying for a decision made by 3 people who had held authority they had exercised without the care that authority required. The reconstruction began the following spring. The contractor selected by the court-appointed monitor was a timber frame firm out of Eau Claire with a strong regional reputation. and they broke ground on the first warm week of May, when the ice had gone out of the lake and the aspens were just beginning to show color at the tips. I drove up to Garnet Lake for that first week and watched the new piers go in, set in the same footprint as the old ones, the concrete forms aligned with the iron stakes Elias had driven in 1947. The stone for the fireplace was being gathered from the eastern bank, the same bank my father had worked, the same stones rounded by the same water over the same decades. A different man's hands would lay them. The fireplace would hold the same heat. I stood on the dock on a May evening, the lake running silver in the late light, the smell of fresh concrete and turned earth mixing with the pine and the cold water I had known since before I could name it. The mallards were back on the cove. A great blue heron worked the eastern reed bed with the same slow patience it had brought to that work every spring I could remember. The aspens along the north boundary were the same aspens that had been there when Elias drove his first stake, grown taller now, their roots deeper in the same soil. The lodge would take the better part of a year to complete. I was in no hurry. The land was not going anywhere. What I have come to understand, in the time since Judge Calloway read that judgment, is something Elias knew when he paid $180 for a surveyor and filed a deed with the county recorder in November of 1947. When an institution with apparent authority makes a claim against you, when it arrives with a clipboard and a blazer and a rehearsed line about compliance, the first question is not whether that claim feels legitimate. The first question is whether it has a legal foundation. The answer to that question is never in the institution's confidence, never in the volume of their correspondence, never in the certainty of their tone. The answer is in the record. It is in the deed, the survey, the plat, the county recorder's files. It is in the documents that were created when the land changed hands and the boundaries were drawn and the instruments were signed and filed. Those documents do not argue. They do not negotiate. They simply state what is true in the register of the law, and they hold that truth against any claim that cannot match them in the record. The record held. It held the way the piers held, the way the boundary stakes held, the way the deed in Elias's strongbox had held through 77 years of weather and time and the occasional person who arrived at the edge of the property with a clipboard and an assumption about what they were entitled to do. The lake was flat and still as I drove away that May evening. The same gray-silver it had been the October morning I came home from Alaska to find everything gone. But different now, quieter. The way a place gets when the thing that was wrong with it has been corrected and the land has had a little time to remember what it was before. If any of this echoes something you have dealt with, a boundary dispute, an HOA claiming land it has no right to, a deed that someone decided to ignore, leave it in the comments. Every situation has its own facts, and the facts are always in the documents.